Ta-da.
Good. Hey, good morning, everyone. I'm Chris Parker. This is Chris Ishihara with the Ishihara and Parker Law Firm. And today our topic is, well, if you're new to Texas, new to the area, what do we need to consider? Kristen, we see all sorts of people come to visit us. A lot of them are new. How's that going? What do we do?
Sure. Today's topic is welcome to Texas. So if you are moving in from out of state, welcome. We right here in Longview get a whole bunch of people relocating, retiring, as well as remote working.
Yep.
Just come in here because we are a great place to live and work and raise a family or retire. Great pace of life out here. Yeah, love Longview. But anyway, if you are that person and you've moved from out of state, if you brought an estate plan with you, there are some things that you need to do. So we want to talk about those.
Yeah, I see so many clients who come and say, Chris, I was in Illinois, California, wherever I came from, and I saw the attorneys there. I got all my documents done, and now I'm moving to Texas, and I certainly don't want to do anything again. I mean, that's the way that it comes to us. Now, Kristen, we've seen a bunch of documents from all over all these different states. What do you think? Is that a problem? What do we need to do?
Sure. So the first thing you need to do is take the current estate plan that you have and have a Texas lawyer review it. That's true no matter what state you move into. The documents that you did in the state that you were in get full faith and credit in another state. They're still legally valid. However, there's some things that you need to have reviewed at wherever you end up, because wherever you die, that's the venue for what would happen for a probate. That's going to control what happens to property you own in that state. So if you come by real property in Texas, Texas law will control what happens to that property, even if you brought in a will or trust from another state. Some things, go ahead.
Well, I mean, I had a client come in, or a story I heard about recently was someone showed up with documents from, let's just say, Ohio. And yeah, it's a power of attorney. It looks somewhat like our power of attorneys, but different. And they're down at the local bank, and the local bank's thinking, hey, we're Vera Bank, we're Eastman Credit Union. We're used to seeing Texas documents 99 out of 100 times.
Right.
And now we have a power of attorney saying, I can do this because, Pennsylvania or Ohio law says I can. And that is a problem. Not that the banks don't want to cooperate or help if they can. They just simply don't know the laws you're referencing.
Right.
You can have the world's greatest documents. They're supposed to be followed. But if nobody knows the underlying law from the state in which you came, it's irrelevant.
Right. The practical answer is 100% of the time, I suggest that folks update their things like financial, medical powers of attorney directive to match Texas forms. There's a way that we do it in Texas. Some of them are statutory. So there's a way that all those people that are used to getting those forms are used to seeing them, and we don't want to confuse them. It's a time when someone's trying to pay a bill for you because you're in the hospital. They're trying to make a decision for you because you're unconscious. So then is not the time to be calling a lawyer and saying, can you prove that those documents are valid? Well, no, it is actually up to that person whether they accept it or not. So 100% of the time, I suggest that you update your powers of attorney to be compliant in Texas.
Yep.
One state that we do get a lot of folks from right now is California. Welcome, we're glad to have you. But in California, they do their estate planning differently. And so if you've done any estate planning in California, you are almost guaranteed to have a revocable living trust to avoid probate there. In Texas, whether you do a trust or a will that gets probated is up to you. Our probate process is much more simple than it is in other states. It also doesn't cost as much. California and some other states allow attorneys to charge contingency fees, which is based on the amount of the estate. So you're really forced to do a trust. Here, you get to make that choice, whatever you prefer. But one thing that I know about reviewing all those California trusts is their wills are not the same. They don't have the same validity requirements that Texas does. So if you probate a will in Texas that was done in California, it's still valid. It's still a correct legal document that can be probated here, but California does not have in their typical forms what we call a self-proving affidavit. So when I've probated a California will here in Texas, I have to go find one of the two witnesses that signed that will. And that's difficult.
Yep.
That can be real tricky. That's usually somebody in the lawyer's office that may or may not still work there. The lawyer may or may not still be working. So at a minimum, when you are moving to Texas, I generally suggest that you update all your powers of attorney and that you need to confirm or redo the will that you have to make sure that it is done under the laws of Texas to make sure that it's a valid will.
And more importantly, just understand the laws of Texas generally. We have folks moving all the time. Texas is a community property state. So when other folks start using words, a usufruct was my Louisiana friend used. I said, I'm so sorry, I don't speak Cajun. The community property state, the rules are different in Texas.
Right.
When you reside in Texas, you may have a different understanding of what the laws are, or at least were where you came from, and it may not be the same here. You may get the same result. You may not. So I've had a few people who had plans based upon laws and states from which they came that don't really make any sense now they reside in Texas. So don't be surprised. I mean, if you come from a state that's not a community property state, things are different, and you kind of need to understand how it works. You can make it all work. You just kind of have to plan ahead and redo your planning if you were doing something unique or different.
That's an excellent point. So in a lot of states, they'll do real property with joint ownership that has right of survivorship. So if I own property, Florida's, I know one that does this. So if I own property in Florida, my deed is likely going to be set up that when I die, 100% of the property now is owned by whoever the survivor is. And so that, sometimes works fine. If you don't want that, I'm sure you set it up another way. In Texas, it's not that way. If I own property with somebody, we're joint owners and my half goes where Texas law says it goes, or where my estate plan done through a correctly done will that's probated or trust says it goes. So it's different. And you're right, people can come in with misunderstandings or correct understandings from the state that they came from, but that's just not true in Texas. And Texas will control where your Texas real property goes.
And of course, with everyone, but especially if you are in a blended family, either one had children from before marriage, and you are moving to Texas, I highly encourage you to see the attorney, because otherwise your family will be after you pass away.
Sure, sure. Last point that I wanted to make today is just talking about the trusts. So a lot of the trusts that we see coming in from other states. Now this one, a lot of times, unless you have changes you want to make, your trust is probably okay. Not always. We restate some of them.
Yeah.
But that is more 50-50 than some of the other forms, I would say. That needs a specific, individualized review to determine whether you need to do something with it or not. But one thing that I know you need to do is make sure that you fund it. A lot of times when you move, you've sold the house, so that was in the trust, but now you've moved here and you bought a house. Did you remember to keep it in the trust? It probably went into your individual name, if I was just guessing.
Yeah, and if I'm putting that house into the trust, I still want it restated under Texas law. But yes, I agree 100%. See people move, you make big transitions for work, you sell all you had in one place, you move to the other, you had a trust, a revocable trust from which you came, and you forgot to now refund it. You should refund it. You should fund that trust with the assets currently in it and take advantage of the trust, and I think you should put it under the laws of Texas. I'm a cautious person, but I don't hit by a car either. So
get it looked at by somebody that knows what they're doing. But you probably bought a new house. You probably opened a new bank account locally. All those things, if you're going to use the trust as your plan, all those things need to stay in and we're specifically talking about revocable living trust for the most part.
Yep.
But if that's the plan that you've brought in, continue using it. Just use it correctly and make sure that you've funded it still that way.
Another good one is I've seen people move and they had old safe deposit boxes back from which they came, and that's where they left all their documents. That does not help you, right? In Texas, we're going to need at some point the original documents, whether it's a will, whether it's a trust, whether it's going to be the powers of attorney. And if you left it back in California, New York, Illinois, someone's going to have to find some way to get that original and present it down here, because at some point, the originals will be needed. So when you are moving, bring your important documents that may not be currently correct to us.
But welcome to Texas.
That's right.
We're glad
That's
you're here.
right.
Just get your estate plan reviewed by somebody that knows how to do it. So,
Perfect.
Anything else?
Nope, that's it. Thanks, y'all.
See you next time. Seems to be a bit of a delay on there.